Hello and welcome, everyone. My name is Brian Walker, and I'm thrilled to be your narrator for today's highly anticipated live stream event. We're broadcasting to you from the offices of Global Talent Immigration Law Group, and we've got an exciting and informative session lined up for you. Today, we're honored to have with us two distinguished experts in the field of immigration law. First up, we have Liz Profumo, the managing attorney at Global Talent Immigration Law Group. Liz brings a wealth of experience and knowledge to the table, and she's here to shed light on some of the most complex aspects of U.S. immigration. Joining her is Jordana Schwartz-Matricardi, an accomplished attorney at law who specializes in helping talented individuals.
I see Marco's in.
Hey,
Marco, how are you?
Immigration law. Together, they make a formidable.
Okay, our first question comes from Lula. How do you hear me?
Now, here's the exciting
That's from Los Angeles.
This isn't just a
Lula asks, I've been told you need to be award-winning to get approved for the green card or have won an award in your field.
Addressing questions that were submitted in advance by
Liz,
our audience. So if you've got questions about O1 visas, EB1 green cards, or anything related to extraordinary ability immigration,
when you apply for an EB1,
further ado, let's dive right in.
there are actually 10 different criteria that the government will consider. Winning awards is one of them. So if you have it, great. If you won, some kind of a national or international award, it's something that is favorable. It's not required. And in fact, we file many EB1s for people that do not have awards.
Today, we're honored to have
next question comes from
experts in the field of immigration law.
If your position in the industry does not commonly get media attention, so your name is not always mentioned in publications, would be associated
experience and knowledge to the table.
With the project featured in a major publications be enough to prove you're extraordinary. Also, what kind of reason you include as part of
who specializes in helping talented individuals.
Okay, that sounds like a two-part question. I will first answer that first part, which I believe what you're asking, Francesca, is whether you have to have press out there written about you, or whether it's enough to have projects that you worked on mentioned in the press. And certainly the evidence of your projects being in the press is helpful to your O1 visa application, in that it shows that the projects that you worked on are distinguished. However, even for someone who may not necessarily typically be in the press, like someone more behind the scenes, it still would be very helpful to your case to get articles or interviews written about you, because that is one of the criteria. If you don't have organic press necessarily, you can certainly do things like hire a publicist, or even reach out to other resources to see if you can have press written about you. But overall, it is very helpful to your case to have public recognition in the form of press. Now, your second question, I believe, was whether emails could be used as evidence for the O1 visa. And typically, we do not like to use emails as evidence. If that's all you have for, to show that perhaps you were had a role in a particular project, like you don't have a deal memo or a contract to show that you were hired for a particular project and all you have is emails, then we can look at that and determine whether that is helpful evidence for the application. But typically, we do not like to use emails for evidence. I don't know, Liz, do you have anything you want to add to that?
No, I think your answer is pretty clear. Certainly having, for the first point, having press about the projects you've worked on can help to show the projects are important and distinguished. So they're helpful, but they don't really check the box they don't meet the criteria about the press being about you. Now, in terms of emails, it's not my favorite, but if it's all that exists, which is the case sometimes, I'll use them in those circumstances. But if there's something more, if there's an official letter that comes from an organization, that would always be my first choice.
Okay, our next question also comes from Francesca in Los Angeles. In this three-part question, Francesca asks, what are some of the current trends and tips to avoid getting an RFE What are your top bits of advice to get direct approval? And what are the best practices that you should look out for when your lawyer is preparing your case?
Okay, I'll start with that one.
Okay.
So there are 3 different kinds of O1 visas. There's an O1A for people that work in business, science, education, and athletics. There is an O1B for people who work in the arts, and then there's an O1B for people who work in film and television. The O1A has slightly different requirements than the O1B, which is for arts and film and TV. So what we see a lower incidence of requests for evidence for the O1As and the O1B in the arts category. The O1B for film and television does have a higher standard for approval. And we tend to see the highest percentage of RFEs in that category. So the first thing, Francesca, you have to know is that unfortunately, any case could potentially get a request for evidence. So, by anyone's best efforts to include every single thing you can think of and make sure every I is dotted and T is crossed. There's always the potential for receiving a request for evidence. So because we don't get many in the O1A or the O1B arts categories, I don't know that I can say that speak to trends in those areas, to be honest. I can speak to a trend that we've seen a lot in the film and television category, which is that USCIS is now taking issue if someone has worked on films that have been exhibited in film festivals. For a long time, USCIS would consider that sufficient distribution to consider the projects to be distinguished and meet the standard for O1 approval. Recently, they have become a lot tougher on film festivals, and they're basically saying that there's so many film festivals in the world now. If you want us to consider your work in festivals, you have to prove those festivals are important within the industry. So it sets a much higher standard for including film festival awards and film festival acceptance. The other trend I would say is that immigration, and this is across actually all categories of O1s, immigration is looking a lot more closely at the job offers than they used to, meaning that they're checking on each company that's providing a job offer to ensure that the businesses are operating from non-residential spaces, that each company is active with the Secretary of State, meaning that they're all up to date on tax payments and registrations with the state are all in order. And that's something that's fairly new.
Our next set of questions comes from Reddick CNC, who's tuning in from London. Reddick has 2 questions related to the EB1 visa process. First, he asks, once the I-140 is approved, how long does it take on average to complete the process? The second question is, can I apply for Social Security after a successful consular interview, but before I enter the US?
Okay, so that's another 2-part question. I will hit the first one first. So the first question, how long does the process take after the I-140 is approved, depends really on your citizenship or nationality. If you are, typically after an I-140 is approved, you can then apply for the adjustment of status straight away. And that will take about 6 to 8 months to process. That's the I-485 petition. And this is if you're in the United States. If, however, you're a citizen of China or India, there's currently a backlog, and you have to wait for your priority date to become current, at which time you can file the I-485 adjustment status, and you will be, again, waiting for, between 6 to 8 months. Liz, do you want to talk about the consular processing timeline?
Sure. And Radek, thanks for joining us this morning. Thanks for tuning in. I hope we'll get to talk to you individually as well about any questions you have. But so once the I-140 is approved for consular processing, the file will then be transferred to the National Visa Center, which is actually located here in the US. They're going to invite us to submit the next application, which is the DS-260 immigrant visa application. We are going to have to send in the supporting documents for that to the National Visa Center. Then they're going to transfer your file to the US Embassy in your country. And then they're going to schedule you for interview. So you're in London. So they're actually, what we've been seeing in London is that they've been moving pretty quick compared to a lot of other consulates. So, or a lot of other embassies rather. So the hope would be that you might get scheduled for an interview in London in 6 to 8 months. I can't guarantee that time frame, but I would say that's about what we've been seeing.
I believe there was a second question that now has slipped my mind.
That's right. The second question is about whether it's possible to apply for the Social Security number prior to entering the U.S. So not a Social Security attorney, but my understanding is that you must be physically present in the U.S. to apply for the Social Security number. When you enter the U.S. with an immigrant visa, excuse me, visa stamp in the passport will actually have a notation that says that this document serves basically as a green card until the green card is issued. So that's what you'll show at the Social Security office upon arrival in the U.S.
We're also getting a question actually in the chat from Alessandra Manias. It says, is it true that it's easier to have a green card if you already own an O1B? And in some ways, it is easier in terms of, the fact that you've already proven extraordinary ability through your O1B approval. And you will also have quite a bit of evidence already to meet, hopefully several of the O1B criteria. Some of that evidence can be used to argue criteria under the EB1 category or the EB1 as well. But there are going to be some additional criteria under the EB1 that are not touched upon under the O1B. So, in certain ways, it is easier again because you've already proven extraordinary ability and you will already have evidence, but it's really going to depend on your particular case and the evidence that you have.
Okay, our next question comes from Antonella Samini, who's tuning in from the United Kingdom. Antonella wants to know, does the O1 visa apply for social media managers?
I'll take that one. So yes, the O1 can apply for social media managers, and actually the O1 can apply for, many, many, many kinds of professions that you might not think are typically, O1 type professions. So really what the government will look for is going to be, does this applicant, does the social media manager have a high profile within the industry? Is there, they've been interviewed? Are they regarded as an expert in the field? So something to consider with social media management specifically, and there's a handful of professions like this. I mentioned earlier there's an O1A for people who work in business, and then there's an O1B for people who work in the arts. So this is also a profession that straddles the line, and so there are different requirements for both. So we'd have to see what this person's profile is, what the background is, to see which area they fit best. We normally like to lean towards the O1B for arts, for creatives, whenever we possibly can, for two reasons. First of all, it can allow a lot more flexibility in who you're allowed to work for in the US. And also, it has a lower standard for approval when compared with the O1A for business.
Our next set of questions comes from Wee Lee, joining us from San Gabriel. Wee Lee has two questions for us today. The first question is, what's the difference between EB1 and EB2 NIW? The second question Wee Lee has is, how can we know we've reached the standard to apply for a green card?
Liz, if you wouldn't mind taking that first question, because I know you have some really good information about it, and I'm happy to do the second
Oh, okay. So the difference between the EB1 and the NIW. Okay, so let's start with what is similar about them first. So the reason that a lot of people will talk about the EB1 green card and the EB2 NIW, which stands for National Interest Waiver, together is that they are the only two employment-based green cards available that do not require sponsorship from a U.S. employer or $1 million investment. So they are highly desired. Now, something they have in common, again, is that they're both they have a high standard for approval. It is not easy to be approved for either the EB1 or the EB2 NIW. So with the EB1, there are 10 criteria that the government has set out, and whatever your profession is, they're going to evaluate your professional history based on these 10 criteria. They want to see that, first of all, you make a minimum of 3 of the 10, and then they want to also see that you're working at, the very highest levels within your field. Now, the NIW has a different set of criteria, which is, it's actually based on a court case. And what they're looking for is whether your work is in the national interest of the nation as a whole, and whether you are well positioned to continue working in that field. So, the NIW tends to be better suited to, people who work in professions that might be related to science, economics, whereas the EB1 might be more applicable to the arts and, a wider array of professions. Also, the EB1 category tends to process more quickly than the EB2 category. So in theory, EB1 green cards are normally available more quickly than EB2 green cards.
And what was the second question again?
How can we know we've reached the standard to apply for a green card?
Well, back to what Liz was saying in terms of the types of, showing that you are very highly regarded at the top of your field. So, that's number one. There's really, again, it's case by case basis, but essentially you want to be able to prove or provide evidence to meet at least 3 of the 10 criteria available for the EB1. And, based on the strength of that evidence, we can determine whether you've reached the level that is required, which is extraordinary ability with a history of sustained success. In other words, top of your field.
We have a question from the chat. How many times can you renew an OB-01B?
You can renew it as many times as you want. That's really one of the upsides to the O1B visa. There is no limit on the amount of times you can renew it, which is actually really nice for individuals who want the ability to, just maybe live and work in the U.S. temporarily, that travel a lot back and forth, who don't have, their ultimate goal is not to become a permanent resident.
Our next set of questions comes from Dennis Alexeev. Dennis is curious about the O1 visa application process and asks, is it better to apply for O1 inside or outside of the U.S.? Second question is, could an Upwork profile with the top rated badge be an advantage in the application process?
You want me to take this one? So when someone applies for an O1 within the US, if you are here with a valid visa, you're eligible to change your status over to the O1 status within the US without requiring any type of interview. This is not true if you're here with an ESTA, but if you're here with an F1 student visa, a B2 tourist visa, another type of H1B work visa, you can change over to O1 status within the US. Outside the US, you will require a consular interview at a U.S. embassy before you can enter the U.S. to start working with the O1. Um, so the consular interviews, I would say, historically are not very challenging. However, since COVID's ended, securing those appointments is more difficult than it used to be. Citizens of certain countries seem to be looked at more closely as well. So my preference for anyone who is eligible to change their status, I would say that's the way to go. But if it's not possible, then you'll have to do that consular interview.
Our next question comes from Michelle Large, who's joining us from Boston.
I think that Dennis had another question about the Upwork.
Upwork
badge. Sorry.
Dennis's second question is, could an Upwork profile with the top rated badge be an advantage in the application process?
So what I would say to that, Dennis, I don't think that squarely meets any of the O1 criteria. However, U.S. immigration is supposed to consider everything that we can present about your achievements. So that's the kind of information that I would encourage you to make sure it appears on your resume or CV that gets included. Because all the details help. But I don't think that having the badge on Upwork necessarily directly meets any of the criteria.
Our next question comes from Michelle Large, who's joining us from Boston. Michelle is interested in the specifics of O1 visas for actors coming from the UK to USA. She asks, what is the process and how has it become more stringent in the last few years?
I can answer that. So the process to getting an O1 as an actor is, well, number one, you need to show that you have at least one offer of employment to work in the US. You need to have the petitioner. It depends actually on the type of O1 case that you are filing. So if it's employment-based O1, so meaning that there's a particular production that wants to bring you on, they can petition for your O1. And in that case, you would be working for the production for that petitioner only. If you are coming to the US to work on multiple productions, then you would be filing what's called an agent-based petition and at least 2 offer letters and a petitioner. And that can be a talent agent, a talent manager, it can even be a business manager. In terms of evidence that you will be providing, as we've mentioned over and over again, for the O1B visa, there are 6 criteria. You're definitely going to want to provide evidence of your leading role on productions that are distinguished. You'll want to get letters of recommendation signed by distinguished people that you've worked with on those productions, as well as other award-winning individuals in your industry. You'll want to collect any press, so any interviews or articles about you and the projects that you've worked on. You'll want to collect any awards or nominations that you or the productions have received. Evidence of the productions doing well, like if you've worked on films that have been theatrically released, on box office numbers, TV ratings, if you've worked on television productions, and then finally evidence of being paid well for your work. So if you collected and saved any contracts or pay stubs. So that's all the evidence that we would want to, collect for this, for the O1B under the film and television category for actors. I believe there was a second part to this question as well. No? Okay. So did you want to add anything to that, Liz?
No.
Okay.
I think that was.
I hope that answers your question.
We have a question from the chat. Is writing and publishing a book or an ebook, a valid and strong evidence valid and strong evidence for an O1 application?
So I would say that any book that is published by a publishing company is good evidence for an O1, no matter what kind of O1 it is. Now, if a book is self-published, I think that in order to be useful, we would have to provide proof that the book has been reviewed or has sales figures that are notable. But if it's self-published, it would have to be some other evidence of its success, in addition to just the fact of publication. But if it's published by a publishing company, I think that, yeah, that's good.
Another question coming from the chat. Is there any advantage to being in the US for 9 years with an O1B visa?
I mean, certainly there is an advantage, in terms of, well, it depends on what you're referring to. So is there an advantage to, renewing your visa? Certainly, because you can show a history of a claim in your field, especially if you've been actively working and, increasing your trajectory has, continued to go upwards during that time. So in that way, yes, there is an advantage to being in the US for 9 years with an O1 visa.
I actually, I think maybe the person might be asking if there's an advantage of being on the O1 for 9 years in applying for an EB1.
Oh, okay.
Well, what do you think about that?
My answer would still be yes. There's definitely an advantage to that for the same reasons that I noted in terms for renewing. Again, it's giving you the opportunity to, be in the States, working on your career, establishing relationships with individuals and companies who can, vouch for your extraordinary ability. And of course, it's giving you that much time to hopefully collect additional evidence, which would then go towards the EB1 card.
Right. I agree with that. But I do also have to say that the standard for the EB1 is significantly higher than the O. So the fact of being approved for O1 status 2, 3, 4 times, it doesn't mean that, you will automatically qualify for that EB1 green card. So I do want to impart that because actually the more times people have renewed their O1, what I find is that when we're working on the EB1, which does have the higher standard and requires a higher level of detail, people say, well, but this worked for my O1s. And so what you have to know is like, well, like the EB1 is a little bit of a different ballgame. So, um, you know, you do have to provide more information, more evidence for the EB1 green card.
Another question from the chat. We have, as a student, in which step in the O1 visa application process can I stop going to school?
Okay, so you can stop. Best case scenario is okay. Let's say that you started your case with us, and you're on your F1 OPT because that's really the most common scenario that we come across. Ideally, you are in F1 status throughout the entire process, meaning up until the time your O1 visa or your O1 petition is approved. At that point, you would then change your status over from the F1 to the O1, thereby no longer being on F1 status. Do you want to add anything?
Yeah, so I totally agree that the safest thing to do is always to maintain your F1 status until your O1 is approved. Now, legally, you are not accruing unlawful presence if you stop going to school after it's filed, but, if you do stop going to school after your O1 change of status is filed, it leaves you in kind of a precarious limbo land, which is not great. So it's always best to wait for the approval before you stop attending classes.
Our next question comes from Eula. tuning in from Los Angeles. Eula has a straightforward but important question. Who can be my sponsor?
Yeah, very straightforward.
It's a very good question.
Okay, who can be your sponsor? So any U.S. citizen or U.S. entity can technically be your sponsor. It's going to depend again on whether you are filing an employment-based petition or an agent-based petition. So if you're filing an employment-based petition, meaning one company is going to be sponsoring your visa, uh, that company must show that it is properly registered and active in the state that it's holding out its business, so that where it's where it has a business address. Um, if it is an agent-based petition that you are filing, then your sponsor, it's a little more, I would say, the requirements are a little looser in that it doesn't have to be a company. It can be a U.S. citizen, preferably in your industry, who is petitioning for your visa. And the type of evidence that they would have to show of their citizenship is their copy of their passport or their birth certificate, as well as their social security number.
I have another question from the chat. What evidence works for EB1A for technology professionals?
So I'll take that one. So for someone who works in tech, so keep in mind that the EB1 criteria, they are the same no matter what field you work in. So certainly if you've won awards, they'll consider that. If you have, because tech professional can be a wide range of things, from the people who are actually doing the coding and the engineering to the people who are kind of out front, public facing within the companies. So if there are, if you've been interviewed or profiled, certainly if you're kind of a public facing person, that's fantastic. Now, if you have ever been a judge, so if, a judge of the work of your peers, so this means you've either peer-reviewed papers, or you might have literally been a judge at a hackathon or some other, or a pitch competition, um, so things that are related to the industry. If you have published papers yourself, not just peer reviewed them, but you've authored them, that's great. Showing for tech professionals, actually for many industries, showing that you have an important role for the company you work for, or for previous employers, or for the department or division you work in, that is great evidence for people in tech. And of course, if you earn a high salary compared to other people who hold your position in your area or your country, depending on the circumstances, those are all strong factors for an EB1 for someone in tech.
Another question from the chat. Do you need a sponsor for the green card or only for O1B?
So for the EB1 Extraordinary Ability Green Card, it's self-petitioning, so you do not need a sponsor, your own sponsor, essentially. But for the O&B, yes, you always need to have a sponsor or a petitioner.
Our next set of questions comes from Cherish Mutambra, tuning in from London. Cherish has two questions related to EB1 visa process. First, she asks, could you talk us through the process after submitting an I-140 application for the EB1 using the expedited option? Her second question is, what happens if EB1 application is rejected, and how do you decide if it's worth refiling the application again?
We did talk about the first question a little bit earlier in terms of the process. After an I-140 is approved, you can either apply, if you're in the U.S. and you're eligible, you can apply for adjustment of status, depending on whether your priority date is current. If it is, you'll hope the adjustment of status application is approved in 6 to 9 months. If you're abroad, you'll have to submit an application with the National Visa Center and then await your interview abroad. Do you wanna talk about the
Refiling?
Yeah.
Yeah, sure. So if you're well, typically, the I-140 petition will not be rejected per se. What will happen is, once it's filed and after it's been reviewed by an immigration officer, if they have any questions or critiques, they will issue a request for evidence, at which point we have, the opportunity to respond to that request, or we can withdraw the application and choose to file it at a later date with taking into consideration oftentimes of the request for evidence of the things that they critiqued. We take those into consideration when preparing and filing the new I-140. And in the event that you respond to the request and it gets denied, at that point it's considered to be denied without prejudice, meaning when you refile your I-140, they should not be taking into consideration the fact that your prior I-140 was denied.
And, I would say to that, how do you know whether to refile, when to refile? I would say that you should get a few different opinions, talk to a few different attorneys who do this kind of work, so you get a sense of whether the case that was filed really was, a strong presentation of your work and your background, and you just happen to have bad luck, or whether, other attorneys might have other ideas about additional evidence to submit or different arguments to make. I think that, that's always important. And by the way, we're happy to have that conversation as well. And something everyone has to know about the EB1 category is it's unpredictable, which means that if you have what we see is sometimes fantastic cases get, hassled, they get requests for evidence and ultimately might even get denied, whereas cases that we think are really not very strong will fly through with no questions asked. Which this makes it very challenging for us because we can predict with very high rate of success whether an O1 will be approved or not. It's not as predictable with that EB1.
We have another question coming in from the chat. Do we need a job offer when filing the I-485 or EB1A?
For the I-485, job offer is not, from my understanding, it's not one of the points that they take into consideration. Now, for the I-140, when we submit evidence with the application, we definitely want to be able to show that the individual is planning to continue working in their field. That important to show, whether that means you have actual offers of employment or, letters of intent that we can submit along with the case, or a declaration that the petitioner, meaning the person applying for the benefit, they can sign a declaration and basically stating that they plan to continue working in their field. But best evidence is actual employment offers.
We have another question coming from the chat. During the green card process, can I travel with current O1B visa?
Ooh, not until you receive your advanced parole travel document. So, excuse me, after an I-485 is filed, if you're an O1 status when it's filed, you cannot travel. If you do travel, I should say, you will abandon your I-485 if you depart the US. Okay, so if you have an H visa or an L visa, you are able to travel throughout the process, but not the O1.
Okay, our last question of the day. Our next question comes from Tony Wu. from Los Angeles. Tony has a financial question about the visa process. He asks, how do you prove the high salary?
There's a few ways to prove high salary. You can prove it with evidence of your past work in the form of contracts, pay stubs, tax returns, even invoices that very clearly note the hours of work that you did along with what you were paid, and then the invoice along with evidence of the deposit being put into your bank, the deposit in your bank account. Um, Now, as far as what is considered high salary, that's case by case basis, just depending on your job title and the area or where you are working. So you can provide evidence of high salary from the country. Let's say that you're working outside the U.S. And all of your payments were made outside of the U.S. We would be comparing your salary um, to what is considered high salary in that country. Now, another way to meet the high salary criteria is with evidence of future work. So if you have offer letters, offers of employment for work to be carried out in the United States, and you will be paid what is considered high salary in the US, that can also be used as evidence.
So, and I completely agree. For the EB1, it's a little bit of a different story. Actually, I think that meeting the high salary requirement for the EB1 is very difficult because USCIS only considers a very narrow kind of forms of evidence, which are really tax returns that show that you earned your wages. It has to be wages through a salary and not through bonuses, not the sale of stock options. So, for the EB1, you would want to be able to provide tax returns with W-2s showing a high salary or the equivalent in your home country.
Wow, what an enlightening discussion we've had today. A big thank you to Liz Profumo and Jordana Schwartz-Matricardi for their invaluable insights into the world of extraordinary ability visas. And of course, thank you to all of you for tuning in and contributing your thoughtful questions. If you found today's session helpful, don't let the conversation end here. We invite you to stay connected with us on our various social media platforms. You can find us on Instagram at instagram.com/global talent immigration, on Facebook at facebook.com/global talent law, and on Twitter at twitter.com/global talent law. We're also on TikTok. Just search for @global talent law. For more resources and updates, be sure to visit our website, www.globaltalentlaw.com. Once again, thank you for joining us today. We